She sued for $1 million. She won. The judge agreed with her. The royalties were hers. The contract was ironclad. On paper, this is a victory. And yet, the 80-year-old woman standing at the center of one of the most famous partnerships in music history just walked out of a California federal courthouse owing more than $1 million of her own money. Not to the other side, to her own lawyers. She won the war, and she's still paying for it. This is the story of how Cher beat Sonny Bono's widow in court, and how the American legal system handed her a bill anyway. It's a story about a divorce agreement signed in 1978. A fight over the songs that made two kids from nowhere into icons, and one word, one legal word, that turned a win into a very expensive lesson. Stick with me, because by the end of this video you're going to understand something most of the headlines got wrong. Let's get into it. Let's start with what actually happened in plain English before we go anywhere near the legal weeds. On Tuesday, July 21st, 2026, court documents confirmed that a federal judge ordered Cher to pay the attorney's fees she racked up while suing Mary Bono, the widow of Cher's late ex-husband, Sonny Bono. Now read that again slowly because it sounds backwards. Cher is the one who filed the lawsuit. Cher is the one who won the lawsuit. And Cher is the one who has to pay. The number she was asking the court to make Mary cover: $1,023,605.30, down to the cents. Plus another estimated $10,000 expected on top of that as the case wrapped up. She asked the court to shift that bill onto the losing side. And on Friday, July 17th, Judge John A. Kronstadt said no. His reasoning, and this is the whole ballgame, was that federal copyright law did not apply here, because at its heart this was a fight about a contract. Not copyright, a contract. And when you're fighting about a contract, the usual rule in America is simple and brutal. Everybody pays their own lawyers, win or lose. So Cher won her money, and then got told the 7-figure cost of winning it was hers to eat. That's the headline. Now let me show you how we got here, because this fight didn't start in 2026. It started 60 years ago with two people, one apartment, and a song you have absolutely heard. To understand why this lawsuit matters, why it's not just celebrity gossip, you have to understand what these two people built together. Her real name is Cheryl Sarkisian. His was Salvatore Philip Bono, Sonny to the world. They met in the early 60s. He was hustling in the music business. She was a teenager with a voice that didn't sound like anyone else's on the radio. They fell in love, they started singing together, and in 1964 they got married. Then came the songs. I Got You Babe, The Beat Goes On, records that didn't just chart, they defined a moment. Two mismatched kids in fur vests and bell-bottoms harmonizing about love against the world. America ate it up. By the 70s, they weren't just a music act. They had their own television show, the Sonny and Cher Comedy Hour, on CBS. They were in your living room every week. They were, for a stretch of American pop culture, inescapable. And here's the thing about partnerships that big. The money doesn't stop when the love does. Sonny and Cher divorced in 1975. But the catalog, those songs, kept earning. Forever. Every time I Got You Babe plays in a movie, a commercial, a wedding, a TikTok, somebody gets paid. And when they split, they made a deal about who that somebody would be. That deal is the beating heart of this entire case, and we'll get to it. But first, the two of them went in wildly different directions. Cher became Cher, the singer, the Oscar winner, the living monument. And Sonny went into politics. He became mayor of Palm Springs from 1988 to 1992. Then a Republican congressman from 1995 until his death. In 1986, Sonny married Mary Whittaker, the woman now on the other side of this lawsuit. She would go on to become a congresswoman herself. They stayed married until January 5th, 1998, when Sonny died in a skiing accident on the slopes near Lake Tahoe. He was 62. So when you hear Cher versus Sonny Bono's widow, understand what that really means. This isn't a squabble between strangers. This is two women, one who was married to him for 11 years in the 60s and 70s, one who was married to him for 12 years until the day he died, fighting over what's left of the music he and Cher made together before either of these marriages was even a memory. That's not gossip, that's Shakespeare. And here's a detail that makes it even more tangled. Sonny and Cher had a child together, Chaz Bono, born in 1969, before Sonny's death and long before this lawsuit. Sonny also had other children. Christine, from his first marriage to Donna Rankin, and Cesare and China, the two children he had with Mary. So when we talk about Sonny's legacy, we're not talking about an abstraction. We're talking about a family tree with branches on all sides. A son with Cher, children with Mary, children from before, all of them connected to the same name, the same songs, the same money. This case is one root of a very large, very complicated tree. Okay, 1978. 3 years after the divorce, Sonny and Cher signed a formal agreement to settle their financial affairs, the kind of thing exes with a fortune tangled together have to do. And buried in that agreement was a line that would echo for the next 50 years. Cher was entitled to 50%. 50% of the royalties from the songs they made as a duo. That was the deal. Half the money from the partnership for as long as the money kept coming. For decades, that arrangement just worked. Nobody fought about it. The checks came, the checks got split, life went on. Sonny died, Cher kept being Cher. And then at some point, according to Cher's own complaint, the checks stopped coming her way. Here's where it gets legally spicy, and I want you to really follow this because it's the pivot the whole case turns on. There's a provision in American copyright law, specifically the Copyright Act of 1976, that lets the original creators of a work, or their heirs, terminate old grants of rights after a certain number of decades and take those rights back. It's called termination. The idea, honestly a noble one, was to protect artists who signed away their work when they were young and broke, and give them, or their families, a second chance to reclaim it later in life. According to Cher's lawsuit, Sonny Bono attempted to use that termination provision to end Cher's rights entirely, to take back the full copyright to the Sonny and Cher songs on Sonny's behalf as his heir, and in doing so, cut Cher out. And Cher's argument in response was essentially this: you can't do that here. That termination provision is, and I'm quoting the language from her complaint, a wholly inapplicable statutory termination provision. In other words, this is a copyright tool and my rights don't come from copyright. My rights come from a contract, a divorce agreement, signed in '78. You can terminate a copyright grant. You cannot terminate a promise. That is the entire case in one sentence. Copyright versus contract. Hold on to it because it comes back at the end and it comes back with a twist. In October of 2021, Cher filed her complaint against Sonny Bono. She sought $1 million in damages. Her position was straightforward. The rights and royalties from those duo recordings, "I Got You Babe." The beat goes on. All of it were being withheld from her, and she wanted what the 1978 agreement promised. Then came the wait, because that's what litigation is. It's not the dramatic courtroom scenes you see in movies. It's years, filings, motions, depositions, delay after delay after delay, 2.5 years of it. And in May of 2024, Cher won. A California judge determined that Cher was owed more than $418,000 in unpaid royalties. The contract held. The divorce agreement held. That 50% promise from 1978, it survived. The court agreed with her that this was a contract dispute and that her share was protected. For Cher, that should have been the mic drop. She sued to protect her half of the songs she helped make famous, and the court said, yes, that half is yours. $418,000 plus the principle of the thing, that a deal is a deal, even a 50-year-old one. So if the story ended in May 2024, this is a triumphant video. Legendary artist protects her legacy. Roll credits. But it doesn't end there, because winning the money and paying to win the money are two completely different things. And that gap, that's where $1 million fell through the floor. Let's talk about how much it actually costs to win a case like this. $418,000, that's what Cher was awarded. But to get that award, her lawyers worked for nearly 3 years. Filings, research, expert analysis, responding to counterclaims. And top-tier litigators in California do not work for gratitude. They bill by the hour, and the hours pile up into something staggering. By January of 2026, Cher's team had tallied it. $1,023,605.30 in attorney's fees. Do the brutal math with me. She won $418,000. Her legal bill was over $1 million. That means the cost of winning was more than double the amount she won. Let that sink in for a second, because I don't think most people have ever really pictured what a 7-figure legal bill represents. That's not a number on a page. That's years of a team of attorneys, paralegals, and experts. People billing $400, $500, $600 an hour and up. Every phone call, every email, every page of every document, every hour spent reading the other side's filings and writing a response. It adds up with terrifying speed. A single contested motion can cost tens of thousands of dollars before anyone even walks into a courtroom. Multiply that across nearly 3 years, across counterclaims and hearings and appeals-adjacent maneuvering, and $1 million isn't shocking. It's almost expected. This is what it costs to fight a well-resourced opponent in federal court in the United States. And it's exactly why so many people with legitimate claims simply walk away, because they do this same math and realize that even if they win, they lose. So her lawyers did the logical thing. They filed a motion asking the court to make Sonny Bono, the losing party, pay those fees instead. And their argument was actually pretty clever. They said, and I'm quoting the filing, "Apportionment of Cher's fees is unnecessary because her successful breach of contract claim and defendant's unsuccessful second counterclaim share a common core of facts." Translation: all of this legal work was tangled together. It was all part of one fight. Cher won the fight, so the loser should cover the tab. A hearing was set, and on Friday, July 17, 2026, Judge John A. Kronstadt handed down his answer. Denied. And here's the exquisite, almost poetic irony of why he denied it. Remember Cher's winning argument, the argument that got her the $418,000 in the first place. Her entire position was, this is a contract case, not a copyright case. My rights come from the 1978 agreement, not from the Copyright Act. She was right. The court agreed. That's why she won. But in America, the rule about who pays the lawyers depends on what kind of case it is. Under federal copyright law, there's a provision that lets a winning party ask the court to shift their attorney's fees onto the loser. Copyright cases have that lever. It's designed to encourage people to protect their creative rights without being bankrupted by the cost. Contract cases, generally, they don't have that lever. The default American rule, lawyers literally call it the American rule, is that each side pays its own attorneys no matter who wins, so follow the trap. To win her money, Cher had to prove this was a contract case. And because she proved it was a contract case, she lost the ability to make the other side pay her fees, because that fee-shifting power lives in copyright law, and she had just spent 3 years successfully arguing copyright law didn't apply. Judge Kronstadt's ruling made exactly that point. Federal copyright law does not apply here because the dispute was over contracts. She won with the sword, and then that same sword cut the other way. Now some of you are already typing in the comments, why didn't her lawyers see this coming? And it's a fair question, but here's the uncomfortable truth about this kind of litigation. The two goals can actively work against each other. To win the case, you argue as hard as you possibly can that it's a contract dispute, because that's the argument that wins the money. But the stronger you make that argument, the more you undercut any future claim to copyright-based fee shifting. Cher's team had to pick a lane. They picked the lane that won her the judgment. You can't fault the strategy that got her the $418,000. It worked. The fee bill is simply the price of the lane they had to choose. And that, honestly, is one of the most under-discussed realities of the legal system. Sometimes the winning argument and the money-saving argument are two different arguments, and you only get to make one of them. And here's something worth understanding about the woman at the center of all this. The royalties case is not the only fight Cher has been living through. Over the past few years, Cher has been involved in a deeply personal legal saga involving her son, Elijah Blue Allman, her child with her second husband, the musician Greg Allman. Cher pursued a conservatorship over Elijah, citing concerns about his well-being. It was reported that she had allegedly cut off financial support to him, then 49 years old, during that conservatorship battle. And that story has continued to unfold, tangled up with Elijah's own divorce proceedings, which have been filed, contested, and revisited more than once. I bring this up not to pile on, and I want to be careful here, because these are real people going through real pain, but to give you the fuller picture of the moment Cher is in. This is an 80-year-old woman simultaneously fighting in court to protect the songs of her youth and navigating a wrenching family situation involving her son. The royalties headline is one window into a life that, right now, has a lot of legal weight pressing on it from several directions at once. Context matters. A headline shows you a single frame. The reality is a woman at 80 carrying several heavy things at the same time, and the songs are only one of them. But let's return to the ruling itself, because I promised you my honest take on it. All right, everything up to this point has been the facts as reported in the court documents and by outlets like People and Rolling Stone. Now I want to give you my honest take, and I'm telling you it's my opinion so you can disagree with me in the comments, which I genuinely hope you do. Here's what I think this case actually reveals. First, this is a perfect, almost cruel illustration of a truth that ordinary people learn the hard way and celebrities can afford to survive. Winning in court and coming out ahead are not the same thing. Cher won a judgment for $418,000, and it cost her over $1 million to get it. If you are not Cher, if you don't have the wealth to absorb that, a win like this one can financially destroy you. The system rewarded her legally and punished her financially in the same breath. And for most people, that math is the reason they never fight at all, even when they're right. Second, and I'll be fair here because fairness matters, I don't think there's a villain in this story the way the headlines want you to believe. It's easy to paint Sonny Bono as the greedy widow or Cher as the litigious diva. I don't buy either. Sonny Bono, as far as the filings show, used a legal tool, the termination provision, that Congress deliberately created to let artists and their families reclaim rights. Trying to use it isn't malicious. It's the kind of aggressive but legitimate move any estate lawyer might attempt. And Cher wasn't suing out of spite. She was defending a 50% share that a court ultimately agreed was hers. Two people, both with a real claim to Sonny's legacy, both reaching for the same thing. That's not villainy. That's grief and money and law colliding, which they always do. Third, and this is the part I find genuinely important, this case is a warning label for every artist alive right now. Cher's rights were protected because in 1978, 3 years after her divorce, decades before any of this, somebody put the deal in writing and made it specific. 50%? Clear. That single piece of paper is the only reason she won. If that agreement had been vague or verbal or never signed, Sonny Bono's termination move might have worked, and Cher could have lost the songs entirely. So to every musician, every writer, every creator watching this, the boring paperwork you sign when nobody's fighting is the exact thing that saves you when everybody is. Cher didn't win in 2024. She won in 1978. The courtroom just confirmed it. And my last thought, the human one. Cher is 80 years old. She has spent the last several years in and out of legal battles, including a very public conservatorship dispute involving her son. And now she's fighting over songs she recorded when she was a teenager, with the widow of a man she divorced half a century ago. There is something almost unbearably sad about that. These songs were about love. I Got You Babe is about two people against the world. And 50 years later it's paperwork and invoices and a 7-figure legal bill. That's what time does to even the most golden things. It's worth sitting with that for a second. That's my opinion. Yours might be completely different, tell me below. Now let's zoom out because this connects to something bigger than Cher. Cher is not the only artist fighting this exact battle. She's just the most famous one this week. Right now, across the music industry, a wave of these termination fights is hitting the courts. The reason is simple arithmetic. The Copyright Act's termination window opens decades after a work is created, and we are now decades past the golden ages of 60s, 70s, and 80s music. Which means the catalogs from those eras, some of the most valuable songs ever recorded, are all hitting their termination windows at roughly the same time. Heirs, estates, ex-partners, and the artists themselves are all realizing the same thing. There is a legal mechanism to grab these rights back, and the songs are worth more than ever thanks to streaming, film, and sync licensing. So you get exactly what happened here. One person says, the copyright reverts to me. Another says, no, a contract already settled this. And a judge has to untangle which body of law wins. Cher's case draws the line clearly. A specific written contract can beat a copyright termination claim. That's not just a win for her. That's a precedent-flavored data point that estate lawyers and artists across the country are going to be reading very carefully. If you lock down your rights in a real agreement, that agreement has teeth, even against the powerful termination provisions of copyright law. But the fee ruling draws a second line just as sharp. The protection of copyright law's fee shifting only reaches you if your case actually is a copyright case. Win as a contract, pay as a contract. You don't get to claim the benefits of one body of law while standing entirely inside the other. Two rulings, two lessons, one legend caught in the middle of both, and there's one more layer worth naming. The reason these old catalogs are worth fighting over at all is that music is worth more today than it has been in a generation. For years, people said the music business was dying, piracy, falling CD sales, the whole doom story. Then streaming changed everything, and suddenly a back catalog of beloved songs became one of the most reliable income-producing assets on the planet. Hedge funds and investment firms started buying up song catalogs for hundreds of millions of dollars. A classic song isn't nostalgia anymore, it's a bond that pays out every single month forever. So when you see a fight like Cher's, understand the financial gravity underneath it. These aren't dusty old records nobody cares about. I Got You Babe is, in a very real sense, a functioning financial instrument. And that's precisely why the people connected to it, on every side, are willing to spend years and millions to control it. The love song became an asset class. That's the world we're living in now. Let's bring it all home. Sonny and Cher made the songs in the 60s. They divorced in 75. In 78, they signed an agreement giving Cher 50% of the duo's royalties forever. In 2021, Cher sued Sonny Bono, saying that Cher was being withheld and that Mary was wrongly trying to use copyright termination to cut her out. In 2024, Cher won. The court said the contract holds and awarded her more than $418,000. Then Cher asked the court to make Mary cover her $1 million plus legal bill. And in July 2026, the judge said no, because this was a contract case, not a copyright case, and contract cases follow the American rule. You pay your own lawyers. So Cher won the money, won the principle, protected the legacy, and still walked away more than $1 million out of pocket for the privilege of being right. Winning and coming out ahead, never the same thing. So here's what I want to know from you. Do you think it's fair that someone can win a lawsuit and still be forced to pay their own $1 million legal bill? Should the law protect a winner's costs no matter what kind of case it is? Or does the American rule actually make sense? Drop your take in the comments. I read them, and the best ones I'll pin. If this breakdown helped you actually understand the story instead of just the headline, do me one favor, hit that like button.